right, last panel of the day, and I have the pleasure of introducing our moderator, Judge Dominique Callins, who serves here in Virginia on the Court of Appeals. She was appointed in 2021. Previously, Judge Callins served as the Family Law Section Leader for Sim Showers LLP. Judge Callins is also part of the George Mason University community. She is a board member of the George Mason University School of Business Women in Business Initiative, which supports aspiring female business leaders through scholarship. Judge Callins received her BA from Florida A&M University and her JD from the College of William and Mary Marshall Wythe School of Law. We're delighted to have Judge Callins moderating this next panel. And with that, I will turn it over to Judge Callins to kick off our final panel.
All right. Yay, yes, it's okay to share. Thank you very much, and I'm really excited to be asked, and I'm honored to be asked to moderate our final, but that doesn't mean not our best, panel. I'm very excited for this panel, for our panelists that we have here today. We have just an amazing slate of experts in the area that we are about to discuss this afternoon, which is the economics and law of arbitration. This is an amazing practice area, and the developments that we're going to be discussing today, I think you will find very interesting. So without further ado, let me introduce our panelists. We have to my right, Brian Farkas, who is an associate with Arent Fox LLP. He's also an adjunct professor of law at Benjamin N. Cardozo School of Law. He writes on arbitration and mediation and has appeared in numerous publications, including the NYU Journal of Law and Business, Lewis and Clark Law Review, Cardozo Law Review, Harvard Negotiation Law Review, and Northeastern Law Review. Our next panelist is Mary Donovan. Mary is a principal at NDP Analytics and a senior economist. She focuses on uniting rigorous quantitative analysis and effective communication to create research materials. She holds an MA in Applied Economics from the University of Maryland and a BA in International Relations and French from the State University of New York, Geneseo. Our third panelist for this afternoon is Stephen Ware. And Stephen Ware is a Frank Edwards Tyler Distinguished Professor of Law from the University of Kansas School of Law. He is the author of 4 books, 46 law review articles, and many other publications. And finally, we have Peter Bowman Rutledge, who is Dean and Talmadge Chair of Law for the University of Georgia School of Law. He is, among other things, the father of 4 children, and the author of Arbitration and the Constitution. Brian is going to start us off talking with us about the recent developments in arbitration law, including some new developments focused on ending forced arbitration of sexual assault and sexual harassment, as well as the impact of the new membership on the Supreme Court on the issue of arbitration law. Mary is going to focus us on empirical research findings and the effect of company arbitration versus litigation and the empirical data related to those outcomes. Steve is then going to talk to us about the economics and kind of summarize and distill some of that empirical evidence that Mary's going to discuss with us, as well as talk about policy values associated with arbitration. And then Bo is going to speak with us about the nuances of international arbitration and the role of state law, including in federal courts. So without further ado, I'm going to pass it off to Brian.
Thank you so much, Judge. Good morning. Good morning, everyone. So good to see you all, and it's such an honor to be asked to speak here. You know, you hear your bio read and you feel really good, and then the next person has like a master's in applied economics, the next person wrote 47 law review articles, the next person wrote a book. Like, all right, I get it. But I'm very honored to sit on this panel of really just incredible people to talk about a topic that I'm really passionate about, which is arbitration. So arbitration, usually is a fairly, I would say, sleepy area of law in the sense that there haven't been that many statutory changes in the broad scheme of arbitration since basically 1925. Essentially, arbitration law has been statutorily pretty stagnant, give or take, for almost a century. And there are updates to arbitration law, of course, that have happened in the last century. Usually that comes in the form of Supreme Court cases or state amendments. And so, it's not as sexy of a topic as something like con law or criminal law or any of the other subjects taught in this building that have a certain allure to it. But this year is actually a pretty huge year for arbitration law because we actually had a major amendment to the Federal Arbitration Act, really arguably the first major amendment to the Federal Arbitration Act. There have been a couple others throughout the last century. So there was, in 1970, the Federal Arbitration Act added what's called the New York Convention, which involves international arbitration. Then in 1990, added a provision on inter-American arbitration, again, relating to international commercial arbitration. But this is really like the first major amendment to the core of the FAA. So big headline to start us off this morning. And as the judge mentioned in her opening remarks, the specific title of that amendment is called the Ending Mandatory Arbitration of Sexual Harassment and Sexual Assault Act. That was signed into law on May 3rd of 2022. So this is very recent, very current. This morning, I'd like to focus my remarks, focus my time on what does this law say, what does it not say, how does it change our day-to-day practice, and I think our other panelists will fill in on speaking from their own angles. They may add some additional perspectives to what I'll say on this particular update. So first thing I'll say is that I mentioned earlier that this was the first really significant act. So let me flesh that out for a second. So the Federal Arbitration Act, I know everyone has different experiences with arbitration from a judicial and practice perspective. The kind of core of the FAA is this language in Section 2 of the act that says that agreements to arbitrate shall be, quote, valid, irrevocable, and enforceable. And when you hear Congress using three words that mean the exact same thing, they mean business. So Congress really meant they want to enforce arbitration agreements. And similarly, in the FAA, there's this provision called in Section 9 that basically forces courts to confirm arbitration awards. There's not a whole lot of discretion. Usually, typically, for the last 100 years, the only way you could get out of an arbitration award is under some very set, established factors or elements that are dictated in Section 10 of the FAA. Those include things that you might expect, like fraud or bribery. Someone hands a sack of cash to the arbitrator. Obviously, a court does not have to confirm that type of award. But generally speaking, the sort of rule of thumb was that once you have an award in hand, it's pretty hard to backpedal your way out of it. It's pretty hard to vacate an arbitration award. It can be done, and there are certainly ways of doing it, but it's not easy. And for years, courts resisted efforts by states to put into place laws that would essentially take categories of disputes out of what could be arbitrable. So there have been states that have tried to eliminate certain categories of, for example, consumer or employment disputes, and saying, you can't force anyone to go to arbitration over a sale agreement. You can't force anyone to go to arbitration over an employment agreement. And time and again, the federal courts have interpreted that language I mentioned earlier, that agreements to arbitrate are valid, irrevocable, and enforceable. Courts have interpreted those agreements to say, sorry, states, you can't enact those types of laws. And that's what arbitration folks call preemption, the idea that the federal FAA preempts any conflicting approaches by the states. So that brings us to the context for this law that I'm addressing this morning. So starting in about 2017, with the rise of the Me Too movement, there was a really massive effort to consider what led to the Me Too movement. What were the social, political, legal causes that led to this sort of confluence of attention around some very prominent figures and some less prominent figures who were essentially found to have committed not just a single act of sexual harassment or assault, but actually repeated acts over many years. Some of the folks who were implicated in the Me Too scandals were public figures for 10, 20, 30 years, and those claims never really saw the light of day. So there were a lot of reasons for that, social, economic, political, cultural, for why those claims remained silent. But the legal aspect was this, this use of arbitration, or one of the legal causes, this use of mandatory arbitration clauses in employment agreements that typically required employees to resolve any and all disputes with their employer through confidential, private, binding arbitration, usually including some form of an NDA, a non-disclosure agreement, as part of that agreement. So that leads us to all of these states around the Me Too movement, 2017, 2018. You saw Washington State, New York, I believe Hawaii, Virginia, California, pass laws at the state level that said, our reaction to the Me Too movement, we're not going to allow employers in our state to require mandatory arbitration of sexual harassment and assault. So they pass all these laws, but what do you think happens based on my comments a few minutes ago? Well, the federal courts essentially say, we love where your heart is at, but preempted. Arbitration Act says valid, irrevocable, and enforceable. So essentially these state-level reactions to the Me Too movement, I wouldn't say that they failed, because I think, as we'll get to in a second, they create this cultural moment legally. But they fail in the sense that, generally speaking, they're either preempted or not really effectively enforced at the state level. But that brings us to this act, which we're talking about this morning. This received, shockingly, broad bipartisan support in both houses of Congress. And I say shockingly because, right? The vote in the House was, one second, I wrote this down because it was like so surprising. It was 335 to 97 in favor of this act. And in the Senate, are you ready for this? Voice vote. Do you know how many voice votes there have been on Senate legislation in recent years? Not a whole lot, right? They couldn't agree to like what they're going to serve in the cafeteria by voice vote. But for some reason, this act actually garnered a pretty significant amount of bipartisan support. And we're happy to talk about some of the reasons for why that might be. But it really did kind of unite the parties on this procedural issue. So what does this act actually say? Well, it says a couple things. Most important, two that I'll mention. It amends the Federal Arbitration Act to prevent the mandatory arbitration of pre-dispute arbitration agreements relating to sexual harassment or assault. And it also bans employers from using class action waivers in the context of those types of claims, which, as some of you know, I know there have been sessions on class actions. That's been an issue in this particular area. Now, that's sort of the headline. But as we know, as lawyers and judges, the devil is always in the details. And this act does have some interesting, shall we say, ambiguities that everyone in this room will have fun fighting over for the next few years, I'm sure. One of those ambiguities is that or it's not an ambiguity, actually, it's just a characteristic of the act. Employees and employers are still able to agree to arbitration of these types of claims, but only after the dispute arises. So if an employee, for example, has a sexual harassment claim, that employee is able to make sort of an informed decision after the point that that claim arises, when the employee is aware of it, knows the players, and basically the calculation, I think, will be, do they want privacy or not? And that's been that is a major benefit of arbitration, is you get privacy, confidentiality. Maybe you don't want your name on a public docket making certain allegations that are sort of inherently sensitive in nature. So arbitration has a huge number of benefits. And what I like about this act, one of the things I like, is it does create at least an option for the employee and employer to come to an agreement after the dispute arises that they do, in fact, want arbitration. So that's one little sort of interesting technicality. Another interesting ambiguity here is that it's not totally clear whether this act is retroactive or not. This is one of those really, like, you have to go into a dark hole on Westlaw to find what I'm about to tell you. But I feel like everyone in this room, I'm getting a nerdy energy, so I feel like many of us probably have gone into dark holes on Westlaw. So when President Biden and Vice President Harris announced this law from the White House, I believe it was an East Room ceremony, Vice President Harris actually made comments saying that this is retroactive and will apply to 60 million Americans who are covered by pre-dispute arbitration employment agreements. And in fact, some of the drafts of this law, both in the House and the Senate, have language that suggests that say that it is retroactive. So every contract, in other words, that existed before March of this year. Well, if you look on Westlaw and look at the version of the act that actually was enacted, it's actually not so clear that it's retroactive. And there's already some litigation bubbling up in the district courts about whether or not it is. So that's not a small issue. Because if you think about almost every employee in the United States, most of them had their job before 2020, of course. So that's a pretty significant area of emerging dispute about this law, is whether it's only forward-looking or not. And I think we're going to see some major litigation on that in the year ahead. The final ambiguity that I'll mention, or sort of strangeness of this law that I also think we'll see some litigation in the years ahead, is when is it actually required to be sent to court rather than arbitration? So here's a scenario, and this is pretty common for those who do employment law. Imagine that you have a case that involves claims of wage disparity and trade secret theft and breach of contract from an employee to an employer, and also sexual harassment. Here's the question: does the entire case, if there's an arbitration agreement in that employment agreement, does that whole dispute need to be sent to court, or can just the sexual harassment aspect be carved out? And one of the things about this act is it actually, under the plain text of the act, it requires the entire case to be sent to court and voids the arbitration agreement, even for claims that have literally nothing to do with sexual harassment or sexual assault. So there are, again, some ambiguities if you go into the dark holes of Westlaw on whether Congress actually meant for that to be the situation. And I think we may see some interest from employers on advocating for an amendment to that for reasons that you can understand, because there's an incentive now for plaintiffs' attorneys to make allegations that might essentially trigger this law, and maybe even knowing that those allegations could get dismissed just because they want to escape the arbitration. So that's something that I've seen being talked about a lot among labor and employment lawyers. So I will stop there because I'm out of time, but I will just say that this is a really major development for arbitration, and I think that if I were to tell you to kind of keep your eye on one area for emerging litigation in the areas that I've laid out on these ambiguities, this is the one to look at. And I think we're going to see some really exciting case law come out of this amendment to the FAA. So with that, I'm happy to take questions and happy to talk more about all of those dark holes of Westlaw and climb through them together with you. So thank you very much for your attention this morning.
All right. Now we go from super detailed, and now we're going to go way high level when we talk about the data. And we talked about arbitration sometimes being a sleepy subject, arbitration plus data. We are going to make this fun, make this exciting, and it's going to be great. So Mary Donovan, NDP Analytics, we have worked on empirical research regarding arbitration and litigation for about 4 or 5 years now. And we began because there was really a lack of comprehensive empirical studies in the literature. What you saw was, empirical studies on litigation in small pieces, or studies of the AAA and JAMS data. But what we really wanted to do, and what we were approached to do, was to be able to combine everything into the same time, a more apples-to-apples comparison of these two forums to see what the outcomes were, both for employers and for consumers. Obviously, it's a huge area of interest. That's why we're here today. And we can't go anywhere without talking about the pandemic. In our most recent data, we did see some interesting findings regarding 2020 and 2021 that we'll talk about briefly. And we'll get into it if we can figure this out. There we go. All right, so we covered the background, but in terms of our data set, just so you're aware, the quick facts, 2014 to 2021 is our data set. Our litigation data is federal court records that are PACER data compiled by a large data service provider. The arbitration is AAA and JAMS, and what we're looking at are outcomes, win rates, awards, and time to completion. So let's get into it. So we'll start with employment. We bucket the cases into three groups. We use settled cases, dismissed and withdrawn, and then decided cases, cases where there was an award. You can see the patterns between arbitration and litigation in the employment area are pretty similar. 75% are settled in arbitration compared to 71% in litigation. 16% were dismissed or withdrawn in arbitration compared to 14% in litigation. And what we're really going to hone in today are these decided cases. That's 9% of employment cases in arbitration. It's 15% of employment cases in litigation. So we take those decided cases, and this is what we use to examine the win rate. The win rate is probably one of the most debated definitions in the world of analyzing arbitration and litigation outcomes. So let me tell you ours. We take the decided cases, we look at cases that have only one prevailing party. That means in the data, if it says both or if it's not there, we're gonna throw it out. There was one prevailing party, and we're gonna count how many times the employee initiated and prevailed in each forum. That's our win rate. In arbitration, our win rate for employees who initiated was 38%. In litigation, it's 11%, so there's a pretty stark difference there. Now, the good stuff. So let's say you won. We're gonna take those employees, they initiated, they prevailed, and here they are, what happened? We look at two factors, time and award amount. Time, this is where our findings differ slightly from previous research, and where COVID really comes into play. What we saw in the litigation data was 2020 and 2021 caseload drops substantially. Arbitration for employment cases, we actually see a steep rise in cases. They also take a lot longer to complete in 2020 and 2021 than they did in the past. So what we see here when we aggregate all the data, 2014 to 2021, we actually see kind of a comparable forum in terms of arbitration and litigation. Arbitration is slightly faster in average, litigation is slightly faster in median. Let's just say that's a wash. When we look at the award amounts, we see a little bit of a different story. You've got a huge discrepancy between the average and the median, which means that in both forums, you have big outlier cases that are drawing up the average. And they're kind of comparable. Arbitration is higher, 444,000 compared to about 408,000 for the average award for employees. But the median is where you really start to see a difference. Both forums drop substantially, but the award amount for arbitration in median is 142,000. In litigation, it's just under half of that, close to 70,000. So, before we move on to our consumer cases, we see in summary that in employment cases, decided employment cases, employees win more often or are more likely to win in arbitration, that the time to completion is a wash, and that the award amounts are slightly higher in arbitration. Consumer cases, when we look at the outcomes, we still see that the majority are settled, but in litigation, 85% are settled. So the vast majority of litigation consumer cases are settled. Just over half are settled in arbitration. And again, we want to focus on those decided cases. That is 6% of the litigation cases in our data set, 15% of the arbitration cases in our data set. So let's see our win rates. In arbitration, consumers initiated and prevailed out of all those decided cases 42% of the time. Litigation, it was 29%. So again, we have a slightly higher win rate in this venue. Here, arbitration is more definitively faster, right? It is faster in average, it is faster in median than litigation. Award amounts, although we see very different values, it's kind of the same pattern as the employment, right? We've got a very high average compared to the median, so we've got those big dollar cases in there. And the average, $79,000 for arbitration, just over $71,000 for litigation. So again, they're similar in average. But then when we look at the median, that's again where we see the difference, right? We see a median award in arbitration of just over $20,000 compared to a median award in litigation, I think I said that right, of under $7,000. So there is definitely in our data set an indication that arbitration tends to produce higher awards than it does for litigation. And that is a ton of data that we ran through very quickly. But I think a few things to just summarize. We do see generally at this very, very high level that arbitration tends to be more favorable both to employees and to consumers. At the same time, a lot of questions are out there. We just talked about sexual assault. We aren't able to pull that type of data out of this data set, right, to compare at the most granular level. What is somebody who individually had this dispute? How do they perform in arbitration versus litigation? We aren't able to make that very, very detailed connection. But at this very high level, these are the patterns that we see in our empirical analysis. So very excited for the discussion afterwards, and I will leave it at that. Thank you. So many numbers.
Hello, everybody. My name is Stephen Ware. I'm a law professor at the University of Kansas. And this is George Mason's Law and Economics Center, so I hope you'll be okay with a little economics at the start of my talk. Now, I promise it won't be esoteric, advanced economics, but real basic Econ 101 kind of fundamental point, which is lower costs to businesses tend to lower prices to consumers. That's the sort of, you can picture the supply and demand curve and where they cross and so forth. So basic point here is that if businesses, lots of them, are using arbitration agreements, they probably tend to benefit from those arbitration agreements. The businesses choosing to use them probably tend to benefit. Not to say all businesses would benefit from using arbitration agreements, or even that all businesses currently using arbitration agreements would benefit from them. Probably some should stop, and they'd have a better bottom line if they did, but most people running businesses tend to do the things that benefit the business. And so lowering costs from dispute resolution is the standard story of why businesses who use arbitration agreements choose to do so. And you can break out those costs into outcome costs and process costs. So by outcome costs, just to use an example, if a business is going to pay $90,000 award from litigation, but only a $70,000 award from arbitration, well, that'd be a $20,000 savings on the outcome of the dispute from arbitration. So it might be that arbitration saves businesses on costs from outcomes that are more favorable to businesses. On the other hand, it might be process costs. If you get a $70,000 award you have to pay in litigation versus arbitration, well, did arbitration go quicker and take less legal fees for you as a business defending the claim? Arbitration, to use a phrase Todd Zwicky used in the last sentence talking about bankruptcy, rough justice in the sense of tends to have less elaborate pleadings, discovery, motion practice, rules of evidence than litigation does. So I teach bankruptcy as well as arbitration, so I kind of see a common thread here of rough justice is sort of my area, quick and dirty adjudication compared to the more elaborate normal civil procedure litigation. So two sources at least of cost savings from arbitration, and you can imagine businesses liking either of them or both of them, and we might be interested empirically in the relative source, the relative contribution each type of savings is making to a business's bottom line. But my econ point I started with was what tends to lower costs to businesses tends to lower prices to consumers. And a lot of people balk at that econ claim because they say, well, consumers are not getting lower prices. It's not like I can have a lower price on some product I buy if I choose the arbitration option over the litigation option. It's really more a question of expanding output through capital moving into an industry or a firm. That's the econ jargon there. Basically, the idea is if a firm is more profitable because it has lowered its costs, it tends to win more customers and attracts more capital and expands. So the idea is, maybe we're getting 5 or 10 cents off the price of something we buy because the business's costs of producing it, including the legal dispute costs, are a little lower due to the arbitration agreement. And that econ point leads a lot of folks who dislike arbitration agreements, particularly the sort of adhesion contract arbitration agreements we've been talking about here in the consumer and employment context, to say, I 5 or 10 cents savings on a product, to lose my legal rights. That's the way they would phrase the trade-off there. And it really does make the sort of empirical data that Mary cited crucial, and it's very contested, is really the point I wanted to make here. It so happens that when I was on the plane flying here, I was reading the ABA Journal. The American Bar Association Journal has an article in its latest issue about arbitration, including the new statute that Brian mentioned. And this article says arbitration is popular with employers because studies show that plaintiffs are less likely to win. According to the American Association of Justice, the 5-year average win rate of American consumers forced into arbitration who received a monetary award is 5.3%. And it's getting worse. In 2020, only 577 Americans in forced arbitration won a monetary award, which is a win rate of only 4.1%. So when the American Association of Justice is presenting the data, consumers win only 4.1% of the time, and they go on to say more people climb Mount Everest in a year than win their consumer arbitration case. So you really have to kind of dig into the methodology of what the different studies are doing, and I'll just flag a couple of issues in that regard. One is the withdrawn or dismissed cases. Mary's data showed for, I think, consumer, much higher percentage of arbitration cases withdrawn or dismissed than litigation cases. And what the American Association of Justice points out is state courts sort of omitted on the litigation. It's so easy to get the federal court data from PACER. It's so much harder with all 50 states to get the state court. But if you think, I used to teach consumer law, and I remember, wow, a lot of consumer plaintiffs' lawyers, they bring their cases in state court, and then the business defendant wants to remove to federal court. So the comparison of arbitration and state litigation is so much harder to get data on, but in some ways the more relevant comparison. And then I'll get to what I think is the big issue and has been for decades now, which is class actions. Particularly on the consumer side, but also on the employment side. So much of what the business community, Chamber of Commerce versus the American Association of Justice, which is the plaintiff's trial lawyers, so much of what they're arguing about is class actions. Because arbitration agreements, Supreme Court has enforced for about 10 years since the Concepcion case, has enforced arbitration agreements as ending class actions, which a non-arbitration contract typically cannot do. So it's sort of a special power of adhesive arbitration agreements that they can kill class actions. And that sure makes them attractive to a lot of business defendants. And so the comparison of individual claimants in arbitration versus individual claimants in litigation, I tend to view the data more the way Mary concludes of individuals do about as well in arbitration, maybe even better, as in litigation, but it doesn't persuade the plaintiff's trial lawyer and many of my very progressive friends who say, hey, it's class actions. That's what we really need for consumers and employees to get justice, and arbitration doesn't permit that. So the big innovation in arbitration, I guess right before the latest one that Brian so nicely summarized, the statute this year, is mass individual arbitration. I don't know if you've heard about these creative plaintiffs' lawyers who take a whole bunch of individual cases and say, well, we can't do a class action in arbitration, but we can file thousands and thousands of identical carbon copy claims in arbitration, and you know what? The business defendant has to pay a lot of fees to the American Arbitration Association or JAMS or who's ever arbitrating it. And boy, that creates a lot of good settlement leverage for the plaintiffs' lawyers at that point. So that to me is maybe second to Brian's statute as sort of the interesting innovation on the cutting edge of consumer and employment arbitration. And then I guess the one other point I wanted to touch on was, and Brian alluded, I think quite rightly, to the Me Too movement, has succeeded on this new statute where the plaintiffs' trial lawyers and consumer groups have been trying for decades to carve themselves out of the Federal Arbitration Act's enforcement. And so much of what the Me Too movement has succeeded with is, yes, the class action point, but really more the confidentiality, or they would say secrecy point. In other words, bringing bad conduct to light and not have it in the closed door of arbitration is the way they describe it. So I promised the judge that after economics and empirical data, I'd kind of try to rise up to policy values here. I really do think the success that the Me Too movement has had in getting a carve-out from the Federal Arbitration Act for sexual harassment claims has a lot to do with that secrecy is perpetuating bad behavior and getting things in court with public dockets, even if it's not necessarily what these two parties would always want. It serves a broader social good, which I think is the class action idea as well, of, you know, sort of broader social as opposed to just the parties individually owning their dispute, which is the traditional idea of arbitration, particularly between businesses. So I do think that's the sort of grand policy debate that's underlying all of this. And with that, I will thank you for your patience and look forward to your comments and questions, and yield the floor to my old friend, Bo Rutledge. Thank you.
Sorry about the Jayhawk, Steve. Good morning. My name is Bo Rutledge. I'm the Dean of the University of Georgia School of Law, and it's a real honor to speak with you all today, both when speaking to a group of judges and when being back in this part of the country. I'm reminded of an incident 17 years ago. At that time, our oldest child was 3 years old, and it was career day at her preschool. And career day was not one of these moments that was about, is your child going to become an astronaut? Are they going to win a Nobel Prize? It was about sitting in a circle, speaking articulately on your feet, answering a question. And so the typical moment at career day went, hi, my name is Steve. This is my mother. Steve, what does your mother do? My mother is a judge. What does a judge do? A judge helps resolve people's disputes. And my name is Mary. This is my father. What does my father do? My father's a lawyer. What does a lawyer do? A lawyer advocates on behalf of his client. Rolled around to our 3-year-old, who had just endured one of my lectures early in my legal career because we had the proverbial childcare emergency. And true story, this is my father. What does your father do? He's a law professor. What does a law professor do? Well, a law professor talks all the time, and he asks lots of questions, and he never answers them. And the fact that my 3-year-old had that insight in my career was humbling. And so ever since then, whenever I speak to a group of attorneys and judges, my goal is to answer some questions, and to the extent that I can't, we'll gladly take them in the Q&A period. To sort of put my priors on the table about arbitration, I would commend to all of you a very wonderful book that was written by some folks that had deep connections to this law school called The Law Market. And it was by two professors, the late Larry Ribstein from the University of Illinois and Arent O'Hara, who used to be affiliated with this faculty and is now the dean at Florida State. And among other things, The Law Market posited that in our modern day and age, many choices that people make, whether in the formation of their contract, the decision about the law that will govern their relationships, or the decision about where and in what form their dispute will be resolved, is in some sense a function of their choice. And so when we see flight to arbitration, or when we see the increased embrace of forum selection clauses, what O'Hara and Ribstein taught us to think about is, what's causing this? What causes people to try to exercise what in the parlance would be called sort of procedural contractual freedom, where the default resolution would be in a court that has proper personal and subject matter jurisdiction over the case. So if we take, for example, the area of international arbitration that Brian alluded to earlier, two of the main reasons why we often see that be the preferred form of dispute resolution in the international business setting is, number one, enforceability. If Mary and I have a dispute, and that dispute goes in front of Judge Callins, and Judge Callins resolves the dispute in Mary's favor, and I'm sitting in France with all of my assets, it may be relatively difficult for Mary to sort of collect on that judgment from Judge Callins. Now take the exact same dispute in front of Arbitrator Callins, rendering the exact same decision with the exact same set of facts under the exact same law, and Arbitrator Callins renders the exact same award in favor of Mary. It is far easier for Mary to take that private decision maker's award to France and execute on my property than if that had been rendered by Judge Callins. That's an example of how the law market operates to enhance the appeal of international arbitration. And so too do we see something similar in the domestic field, particularly as Brian and Steve indicated, with the demise throughout the 20th century of the non-arbitrability doctrine, the increased utilization and acceptance of arbitration in domestic settings, consumer, employment, securities, and otherwise. Now, we don't have the same enforceability question right, because whether it's a judgment or an award, we either have the benefit of the full faith and credit clause or the benefit of Section 10 of the Federal Arbitration Act. And yet, nonetheless, the law market would teach us that there are reasons why parties are pivoting to that choice. One reason that's been alluded to already is the potential value of arbitration as a confidential form of dispute resolution. Another that you often see is the value of procedural autonomy. When I teach my students arbitration, one of the questions that I ask them, as I say, all of us have had the experience of being in the grocery store. And if you had two options, option one is to sort of get in the line, and option two is to sort of designate your own line in the grocery store, what would you opt for? Would you like to have the opportunity to sort of go over the front of your own created line? And I think one of the reasons why you saw that flight to arbitration over the last 2 years during the pandemic was one of the features of arbitration, whether in the international or domestic setting, is the procedural autonomy. If parties chose to agree to have an entirely virtual hearing, they could do so, and the arbitrator would presumptively be bound by that agreement, all of which are sort of manifestations of what I refer to as the law market. So with those priors on the table, let me make 3 brief points. Point number 1, and this sort of picks up on Mary's path-breaking research. I cannot commend to you enough the work that she is doing to sort of crack the nut of what's really going on in arbitration compared to litigation. Point 1 is sort of beware the untested empirical premise. Now, all of you are judges, right? And so you're accustomed to somebody coming in front of you and saying, this is universally true. Hundreds of thousands of people are doing this right now, whether it is embedding arbitration clauses in your cell phone contracts or engaging in some other form of activity that the lawyer in front of you is seeking to dispel. Well, that was the kind of thing that Steve's colleague, my co-author, Krista Hosel, and I could test. So far before Mary was able to sort of bring her big data analytics to the table, Chris and I began to look at, for example, credit card subscription agreements. And what we found was something quite shocking, that at the time when there were sort of broad brushstroke arguments being made about the pervasiveness of arbitration clauses in the credit card industry, we found that, in fact, that was somewhat not true. That as an empirical matter, if one looked at credit card issuer agreements, that only about 50% of credit card issuers were using arbitration clauses. We saw a similar pattern in franchise agreements. Now, that's not to say that that was sort of the beginning and the end of the debate, because when one looked at it not from the perspective of the percentage of issuers utilizing these clauses, but instead looked at it by reference to the aggregate amount of credit card debt in the United States. Although only roughly about 50% of the credit card issuers in the United States were using arbitration clauses, 95% of the credit card debt in the United States was subject to arbitration clauses. That was as a result of the fact that a relatively small number of credit card issuers held the vast majority of credit card debt in the country, and all of them were using arbitration clauses, perhaps for some of the reasons that Steve gave. A similar untested empirical premise that you all will be familiar with as judges, what I would call sort of the if-then argument, the parade of horribles. If you decide X, Y will inevitably occur. And that too was something that my co-author Chris and I decided to examine. In this case, we looked at the Concepcion case that Steve alluded to earlier. That tested the question whether an arbitration clause in conjunction with a class action waiver was unconscionable, and if so, whether or not that unconscionability finding was preempted by Section 2 of the Federal Arbitration Act. The Supreme Court said no in Concepcion, and everyone said, well, if that happens, everyone's going to pivot to arbitration agreements. And as we found both in the franchise sector in our Vanderbilt Law Review article, and as Chris found more recently in his Case Western article that was in the reading for today, that flight to arbitration did not occur, even after a decade following Concepcion. So number 1, beware the untested empirical premise. Number 2, for those of you who sit in the state judiciary like Judge Callins. State law matters. State law matters in arbitration. We often hear about sort of the brooding omnipresence of the Federal Arbitration Act. And in fact, the law applicable in this context is far more complex. We know from Section 1 of the Federal Arbitration Act that the FAA doesn't cover certain types of contracts in interstate commerce. And just this past term in the Southwest Airlines versus Saxon case, the Supreme Court held that an entire swath of workers in the airline industry fell outside of the FAA's ambit. There's a similar set of litigation percolating in the lower courts right now about the extent to which the Federal Arbitration Act's provisions will govern in industries like Grubhub and other sorts of online delivery services. So state law matters and the FAA doesn't apply. Number two, state law matters and the FAA does apply. You've heard at various times over the course of the panel today how Section 2 of the Federal Arbitration Act can preempt, can displace state law. But ultimately, the question that judges, whether state or federal, confront when asked to test the enforceability of the arbitration agreement is whether or not this agreement is valid under, quote, generally applicable contract offenses. And the relevant point of reference for those generally applicable contract offenses is state law. Now, one of the interesting things that Brian mentioned about this new Chapter 4 of the FAA that I think presents a puzzle is Chapter 4 of the FAA, this provision having to do with the enforceability of arbitration clauses in certain clusters of sexual harassment and sexual assault claims, actually federalizes this area of law. And so I think it begins to sort of put a little bit of attention on exactly the relationship between federal and state law when one's dealing with the enforceability of arbitration clauses. The last way in which state law matters is state law can fill the gaps. Many of you come from states around the country, and you may be surprised to learn that notwithstanding the association that we often have between international matters and federal law, that nearly half the states of the Union have their own international arbitration codes, which oftentimes are far more developed than the federal law, at least the federal statutory law, governing international arbitration. As a consequence, whether you are asked, say, in New York, to engage in a pre-dispute freeze of assets, which a provision of New York law allows you to do before an international arbitration is even filed, or whether you are asked in Georgia, my home state, which under its international arbitration code allows you as a court to undertake certain emergency equitable relief at the front end of a case. State law matters because it fills the gaps. The final point that I make, because Brian didn't get a chance to get to it, I highly commend to you his forthcoming article on the effect of changes in the Supreme Court as it will bear on arbitration law. We've obviously seen several. His article talks about the change from Justice Ginsburg to Justice Barrett. And I think the interesting question will be, number one, the extent to which federalism values become more ascendant than they were. Justice Ginsburg was often the author of some of these decisions that held the Federal Arbitration Act displaced state law. Justice Barrett hasn't been asked to weigh in on that question. But more recently, just this past term, Justice Barrett was the author of a unanimous opinion cabining the availability of a judicial remedy in international arbitration, namely Section 1782. The idea being that if Mary and I have an international arbitration in Switzerland, if there is relevant material in the United States, could we get a court in the US to subpoena either a party or a third party to produce that information in support of the arbitration abroad? Justice Barrett, speaking for a unanimous court, said no, in a decision that was somewhat dismissive of a decision from Justice Ginsburg roughly 15 years ago on a related matter. So too, I suspect we'll see a good deal of change in the court as a result of the arrival of Justice Ketanji Brown Jackson, replacing Justice Breyer. Many of us think about Justice Breyer as this great scholar of administrative law, the person who could ask very profound, sometimes paragraph-long questions in oral argument. He had an incredibly interesting streak in arbitration jurisprudence. And the consistent streak in arbitration jurisprudence by Justice Breyer was immense deference to the arbitrator and an immense opportunity for parties to engage in contractual choice, including delegating matters to the arbitrator provided that they did it so clearly and unmistakably. Questions will remain whether or not, with his retirement from the court, Justice Jackson will continue the mantle of her mentor and former boss. And with that, hopefully I've answered a few of your questions. If I haven't, I'll be happy to do so in the Q&A. Thank you.
Thank you again to all of our panelists. And before we begin with questions, my first question is to you all, and whether there were any points that were made by your co-panelists which you would like to amplify. Okay, it looks like everyone thought. Brian, go ahead.
Well, I think I love hearing these remarks. I think that the data is so interesting that Mary presented, and I think the contrast that Steve brought out about, he's reading this ABA journal that says basically the opposite of what Mary put on the screen. It really shows you that a lot of these studies, you need to really dig into the meat of what is being evaluated, how, as Mary said, what the definitions are that are being used. So that point just really stuck out to me, the distinction between conflicting claims and the importance of evaluating primary sources.
Yeah, Steve, I'm really glad you brought up that article. And I think there's two things. One, there's the definition, but there's also the relative difference, right? So you can divide anything by a larger number and get a smaller number. But what really matters is how it compares to the other forum, right? We can say arbitration is awful because only, you could climb Mount Everest before you won a case, but you also need to say, okay, what's that equivalent in litigation, right? And a lot of times in these types of articles, we don't see that relative comparison. So we had a lot of fun reading that. Thank you for bringing it up.
Yeah, Mary's point is huge about use the phrase apples to apples. When you're doing any empirical comparison of two things, that's what you're trying for, is as much of an apples to apples comparison. Instead of comparing the ugly reality of one system with the idealized theoretical perfection of the other system, right?
Well, thank you for that. So if we can go back to the beginning of the discussion about this new act ending the mandatory arbitration of sexual assault and sexual harassment claims. You promised us that there were some really interesting reasons why this act was overwhelmingly supported on a bipartisan basis. Can you tell us a little more about that?
Sure, thank you for the question. It really is very unusual to have this level of support in both houses, as I said. I think there are a few reasons for it. One is that it's really hard as a political matter to come out against ending something related to sexual harassment and assault. It's kind of a hard speech to make, especially in the context that we're in of the Me Too movement. I also think that this was an unusual situation where there was a lot of mobilization over a period of many years by advocates in a really strategic way to get this litigation get this legislation passed at the federal level. And there wasn't really a cohesive strategy on the other side, at least that I saw. I didn't see typically it would be like I would assume the Chamber of Commerce, other groups such as that are typically on the pro-arbitration side. And I didn't really see a very cohesive advocacy strategy that was lobbying against this amendment nearly to the extent that I've seen lobbying on other changes. For example, when there have been proposals to eliminate consumer arbitration, there were law firms wrote amicus briefs, and there was sort of a cohesive movement, and there really was not that cohesive opposition to this act. And then the third thing I would mention is just I think the culture has changed, and that has impacted everything from media to news coverage, and I think that's why it made it so relatively easy and positive for many politicians to sign on to this across the aisle.
Please.
I agree with everything Brian just said, and notice how the folks who want to end enforcement of consumer adhesive arbitration agreements are trying very much to sort of repeat and piggyback off of the success they had with the employment side. And The House of Representatives this year, again, passed a bill that would do that, as Brian mentioned, a wide range of disputes. And the Senate, as we know, is closely divided. And there's been a couple Southern Republicans, Lindsey Graham and Senator Kennedy of Louisiana, who have sometimes sided with the plaintiff's trial bar against the business community on these issues. So I guess that's who I would say to watch to figure out if the Senate might actually pass this broader bill that the House has passed.
Yeah, the only thing I would add, and Steve touched on it a little bit, so these debates over federal rules governing the arbitrability of certain clusters of disputes have been with us for roughly 35 years. And what happened was, from about 1925 until the mid-70s, you had this fairly robust doctrine of federal law called the non-arbitrability doctrine. And in essence, what it said was, if the federal government creates federal jurisdiction and creates a federal cause of action, that it's somehow inconsistent with the spirit and intent behind that law to allow a dispute arising out of that law to be taken out of court. That doctrine began to sort of crumble in the early to mid-70s after the United States acceded to the New York Convention, that international arbitration treaty that Brian alluded to earlier and that I was sort of talking about with my example of how arbitrator Callins's decision would have greater currents in the international market than Judge Callins's decision. From about the mid-70s until the late 80s and early 90s, that decline of the non-arbitrability doctrine in the international setting began to sort of creep into domestic disputes as well. And the argument basically was essentially, if it's good for international, it's good for domestic. Therefore, whether it's an international antitrust dispute or a domestic antitrust dispute, we have these experts called arbitrators. We can allow things in front of them. And then in '91, in a case called Gilmer versus Interstate Johnson, that was sort of a huge pivot point where all the federal employment discrimination claims were now found to be arbitrable. Really, from Gilmer until today, there has been a recurring effort to pull that back. And that effort almost invariably has failed. And there may be a variety of reasons why. Nonetheless, while it is technically true that the FAA hasn't been amended, it is equally true that there have been other amendments to federal law that have chipped away at this non-arbitrability question. So beginning in the early 2000s, out of nowhere, a federal law passes that declares unenforceable disputes between automobile dealers and distributors. And I think there's some political economy behind why that became important in that particular niche of the law market, if you will. And that really started a pattern that you've seen at least a half dozen times. Automobile dealers and distributors, poultry wholesalers, defense contractors, residential mortgage contracts. The effort to sort of have this battle over arbitrability versus non-arbitrability has been much more successfully waged on these sort of small wedge issues as opposed to the big kahuna of let's just overrule everything from the mid to late 80s to the early 90s jurisprudence. And so I see this new Chapter 4 as simply the latest iteration in that ongoing incremental strategy.
So what I found kind of interesting in reading our materials for this panel is this theory of using arbitration and reasoned decisions almost, well, one of the theories was as a displacement for judicial opinions, and how it didn't look like when it came to the idea of allowing these reasoned opinions that there's much incentive for arbitrators to do that. Have you found that that has changed, and in what ways?
Yes, I have found that it changed. The traditional commercial arbitration award is just a sentence or two, you know, who wins, what's the remedy, as briefly as possible, because the traditional wisdom, and this is what the American Arbitration Association taught new arbitrators when I went through the training to be an arbitrator, was, boy, the more you write, the more a court can look at and find flaw in. So keep it concise, brief, and the court will rubber stamp it and confirm your arbitration award. And what has happened over the decades of the history that we just heard is more and more cases, arbitrators giving reasons, partly because the parties are asking for it, and partly because there's pressure on the arbitration organizations, particularly in the consumer employment kind of cases, to you know, show a just outcome. And I do think it's a great example also of the law market point that Bo made, which is if we can move from the consumer employment to the business side of it, you can really imagine businesses, particularly in the same trade association, the same industry, with a lot of technical specialized knowledge, and their arbitrators have the technical specialized knowledge, making better decisions, better precedent than generalist judges, for all their strengths, can do. And it seems to me a really good public policy question of reminding ourselves that courts are subsidized by tax dollars, whereas arbitration parties pay for their own adjudication. And you all judges are such precious resources, as of course our courthouses and juries and the whole court system. Who should be getting the subsidy that you all provide of subsidized adjudication, right? Should it be two big businesses that had a big contract that their lawyers customized, and they could have put an arbitration clause in there where their adjudication would be borne the cost by themselves? Or should the subsidy of courts, the openness of courts, go to parties who couldn't have done all that? I think that's the kind of big, grand public policy question of litigation versus arbitration at the business level. And I love the metaphor of a law market there, picturing sort of courts and arbitrators competing with each other for the business of adjudication. I think we have some questions too.
Please.
Is it possible that the business community has scrutinized the differences and then the relative balances of outcome versus process cost such that it's to their benefit if Mary's numbers are, believing they're correct, apples to apples, that they would rather be in litigation rather than arbitration, such that their cost of goods are less? Ultimately, bottom line.
Some have.
Thank you.
I would say no on the speaking from the sort of like more defense side from a large law firm. In the experiences I've had so far, the costs are, I mean, you can never generalize completely, but it's almost always faster, cheaper, quicker, more efficient, better, less stressful for the lawyers. Everything about arbitration as a process for the parties is usually better from what I've seen in terms of cost and time in particular. But I think, to your point, there are certainly exceptions, and I think the data show that it's not always the case, and parties do make individual choices.
And I would say the one illustration of your point that is sort of borne out by the contracting practices goes to this issue of the interplay between arbitration and aggregate litigation. Particularly after Concepcion, as we sort of talk about in our paper, for companies that have concluded we prefer arbitration to litigation, the big but is, but if any part of our aggregate litigation waiver is found to be unenforceable, then we want that to go to court, because we'd much rather have the aggregability or non-aggregability of a bundle of claims judicially tested either under Rule 23 proceeding or otherwise, than to have it sort of pop around in arbitration where, as Steve said, it's much harder to get sort of a definitive early ruling on the extent to which those claims can be bundled or not.
Go ahead.
I'm Robert Johnson. I'm a Tunica Biloxi tribal judge. I think I may be the only tribal judge here. But I served 12 years in the Louisiana legislature. I carried a similar provision to do away with arbitration in sexual harassment claims on the state side in Louisiana. It didn't even make it out of committee, and it was, just showing the difference in the times. But in your study, Mary, did you study those cases that don't get to arbitration, that don't get filed? Because of, like, we had issues with forum choices, which were out of state for Louisiana consumers who had been sexually harassed. And so I found, or what they had found, that was the reason for the legislation, is people couldn't afford to get to the arbitration. Not that it was a bad idea to do it, but they just could never get there. So that was the issue because of the fact of the cost, being states away, finding a lawyer. Louisiana law is a civil code versus the common law of other states. So it was very difficult to find for those in Louisiana who fell victim to those things. I mean, now, obviously, the federal laws changed that. But did y'all study that?
No, the database that we have only has
Those that
cases
actually went.
that terminated, right? And I think a big question out there, both on the litigation and on the arbitration side, is how many people are trying to get into these processes. But unfortunately, the data availability, as far as I know.
I don't know where you'd go to even find that unless
Yeah.
people voluntarily said I had a claim. I just
Right.
couldn't pursue it because no lawyer would take it because it was out of the state, and the arbitration had to occur out of a different form from where I lived or my domicile.
Yeah.
So that was one of the issues that I thought, it's not that I think arbitration is bad, it's just that if you can't ever get to it, then it becomes a deterrent for people who have legitimate claims to be able to process those claims. And if they have to be done in arbitration first, before you even get to a courtroom, you're just probably not going to file your claim.
Yeah.
And those are the sorts of issues that generated a lot of unconscionability cases in courts of requiring consumers to travel a great distance
Right.
to bring a small dollar arbitration claim, or having arbitration fees higher than the claim was worth. Those are the kind of things courts have policed with unconscionability. And it's a nice example of Bo's point about how the Federal Arbitration Act, Section 2, kind of incorporates state contract law
Right.
to say that normal defenses to enforceability of any contract are also defenses to enforceability of arbitration.
I just find it and again, I sit in a very small venue. I just have a tribe's jurisdiction. But like in regular court systems, I practice law as well. I find that the cost of litigation is so exponentially high right now. There are a lot of people who can't ever get access to the court system because, and they may have very valid claims, and if policy, on the legislative side doesn't take care of those things, but those individuals just never get their justice because the justice is cost prohibitive. So.
Thank you. If we don't have any other questions, I think we are at our time, so I'd like to thank our panelists once again. And thank Mason School of Law.
Thank you very much. Thank you, Judge Callins, and to our entire panel for closing us out. And thank you to all of you. First, thank you to all of you who are here. You are the folks who will be reimbursed. You think I'm joking. But it's been a delight to have all of you here. This was a wonderful conference, and it really is made that way because of all of you attending and contributing your discussions with us in the breaks, our discussions afterwards, our discussions with our panelists. It really works when we have panelists who volunteer to be part of this program, so we thank all of them who've been part of it. I do want to take one brief moment to thank the LEC staff who's been critical to all of this, and unfortunately, I don't think any of them are currently, well, some of them are here, but so there's Heather Parrish. Heather Parrish, who was our events coordinator, who made sure that we all got fed well and that the facilities were in proper order. Ashley Evero-George, who's our associate director of the Judicial Education Program and really was in charge of designing every element of this program and making sure it ran on time. And then those who assisted her, including Dominique Scavuzzo, who is one of our program assistants, Ian Spears, who is one of our program assistants, and Andrew Dowlis, who was here, and Rebecca Thacker, who is our associate director of the JEP, who you met briefly, who were in and out for part of the program. And of course, everyone upstairs who has been a part of our staff and critical to making this run well. And I would go, and I can't go without saying that Henry Butler, our executive director, and Paige Butler, our other deputy executive director, really provide the leadership that makes all of this possible. So I thank all of them for being so critical to the success of the LEC. We are adjourned at this point. I believe that Ashley has given you all the information you need for the closeout. If you have any questions about any matters, please feel free to reach out to us. We hope that for those of you who this was your first event, please know that we have different formats. And so, the Econ Institutes, which are coming up that you can sign up for, our week-long lecture formats. We have a variety of different programs available besides the symposium format. We hope this will be the first of many programs that you will attend. For those of you who've been with us before, please do come back again. And the last thing I'd like to ask is that we really work well by word of mouth. The way that we recruit attendees is when you go back and talk to others in your chambers, around your building, and let them know about what the LEC is doing and about why you thought that coming here was valuable. And we'd love to add people to our roles. So on that survey that you get from Ashley, it does include a place where you can suggest that you confirm that we actually have some of your colleagues on our mailing list that we should. But we also would love for you just around the water cooler to let some people know that they should go to masonlec.org and look at programs that they can apply for. And that is continuously updated. We will also be reaching out to all of you by email to let you know about things that are upcoming. So safe travels to all of you. Thank you again for being part of the program.